right, we're on the record in cause number DF250640. Councils, will you please announce for the record?
Holly Draper, along with my associate Sarah Yates, here on behalf of the petitioner, Sergio Hernandez.
Thank you.
And Chris Cantu, on behalf of Antonia Macedo, the respondent.
Thank you. And those who intend to testify, would you please remove yourselves off of mute and raise your right hand? And Antonia Macedo?
Yes.
Thank you. I can see you. Okay, raise your right hand. Do you all swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes.
Thank you. You may lower your hands. So we are set today on a bill of review brought by Attorney Draper and Attorney Yates on behalf of Mr. Sergio Hernandez. Is that correct?
Yes, Your Honor.
All right. Prior to going on the record, there were exhibits that were pre-admitted. They will be admitted at this time. So petitioners exhibits number 2, 9 through 20 are admitted, and respondents exhibits 1, 2, 3, 4, 6, 10, 11, and 12 are admitted. Is that correct?
No, Judge. Well,
Did I miss one?
no, okay, never mind, Judge. Sorry, I'm sorry. You said 2 and then 9 through 20. Okay.
Yeah.
Right. No, sorry about that.
That's okay. That's okay. All right. You all have 15 minutes aside. The court has reviewed the original petition for the bill of review as well as the amended answer that was filed. And you all can use your time however you wish to. You can make an opening and a closing statement should you choose to make one, but it will also include any examination. Attorney Draper, at this time, would you like to make an opening statement?
Yes, Your Honor.
Go ahead.
Your Honor, I'm here on behalf of Sergio Hernandez Jr., who was party to a divorce that had a trial in front of Judge Cooks back in October of 2022. In that divorce proceeding, there were ultimately several properties addressed that were not properly addressed. For example, we have property that was not actually owned by the parties that was included. And the part of the reason for the confusion relates to my client and his father having the same name. There was a previous hearing related to an enforcement and clarification in this matter, where the court, in my client's understanding, acknowledged that there were mistakes that needed to be corrected in the final decree of divorce, and he was advised that he should appeal. Because at the time that happened, there was not sufficient, it was too late to file for an appeal. So that is why we are looking at this bill of review. He has a meritorious defense to the property division and that there's proof of non-ownership of real property that was awarded in the divorce decree. He also has a meritorious defense in that there's proof of non-ownership of a business that was awarded to him. And by including these pieces of property, both real estate and non-real estate, in the property division, it led to a division that was not just and right. Mr. Hernandez was unable to appeal as a result of official mistake. That mistake being that despite numerous requests to the court reporter and paying for the transcripts, the court reporter failed to ultimately produce transcripts. And this led to the court reporter's loss of license for a period of time. Mr. Hernandez has no adequate legal remedy available to fix the property issues within the decree other than a bill of review. So he would request that the court set aside and cancel those portions of the decree rendered on July 3rd, 2023 related to property division and order a division of the estate of the parties in a manner that the court deems just and right. Thank you.
Thank you, counsel. Attorney Cantu?
Yes, Judge, briefly. I believe now we definitely have a pretrial bill of review matter to attend to based off that opening and their own pleadings. So the pleadings for the original petition for the bill of review states meritorious defenses, the same defenses he brought and tried to allege during the trial. At this point, this is not a bill review wherein the petitioner movement for the bill of review was defaulted. He was full participant in the trial. He alleged these same defenses. You don't allege your same defenses as a meritorious defense again in an original petition for bill of review. In fact, when you are an underlying participant, you actually have to present a meritorious ground for an appeal. Alleging a legal theory for defense does not suffice. And I have the case law to back that, Judge. But either way, if you look at the original petition for bill of review, and Her Honor we're supposed to consider what they pled and any evidence attached. The only evidence attached is the agreed final divorce decree. The agreed final divorce decree says that the property awarded was community property and that the third parties held such property in constructive trust. So we have findings in the in the final divorce decree attached as their evidence that would preclude them from trying to say, well, my meritorious defense is that these shouldn't have been included. That would be a meritorious defense if he had been defaulted, but he presented these already. So that's why I have claims of res judicata and statute of limitations. He can't claim the same defenses. So through their own pleadings and that opening and their only attached evidence to the pleading, they have an issue to go forward on an actual trial for petition for bill of review because they have not presented a meritorious ground of appeal through a prima facie showing, which is just on the face of the pleading, Judge.
May I respond, Your Honor? The requirements for prima facie showing are met by the fact that this petition for bill of review is verified as to the facts that are alleged in the petition by Mr. Hernandez. There's case law out of the Texas Supreme Court stating that affidavits and such sworn testimony suffice for a prima facie showing, and here a verification serves the same purpose as an affidavit in swearing to the truth of the matters contained in the document. And maybe this came up in the trial, maybe it didn't. I don't know that. The court doesn't know that because there is no transcript. And the official mistake of having lost transcripts and never been able to produce them has put us in the situation that we're in right now.
So, Judge, I will reurge just having a ruling on, based on what they're saying, that there is no prima facie case for a ground for a bill of review. Again, because he verified that what he's saying in the petition doesn't automatically doesn't get you that ground. You have to, within the petition, show why you get the ground. And it can be verified. You can attach it to affidavits. You can attach whatever. But as we know, in case law, again, the invocation of a valid legal theory is not itself sufficient for a bill of review to establish the burden of a meritorious ground for appeal. Ms. Draper keeps saying the same thing. Well, we included properties that shouldn't have been in there. Okay, so that would be a ground of defense for the judgment had he been defaulted, not a ground for appeal. There's very specific things you appeal when you go above, and it has to do with evidence or lack thereof. The other problem they're having, Judge, is she's calling an official mistake there not being a court reporter's record. That's the biggest issue that they have. The problem with that is that's not an official mistake, and I have case law on it. An official mistake would have been Mr. Sergio relying on the court to give him notice that the judgment got signed, and he didn't get notice, and then ran out of time to file a motion for new trial or appeal. I have case law from the Supreme Court that says when a party fails to timely avail itself of its legal remedies, you don't get a bill of review. In fact, since 1967, French v. Brown, Texas Supreme Court, it states, when one has the availability to appeal and fails to pursue that remedy, you can't seek bill of review. A bill of review is unavailable in this particular case, in French v. Brown, when the claimant filed a motion for new trial, failed to carry it through, and then failed to do a direct appeal. That is almost exactly what happened here. Mr. Sergio Hernandez filed a motion for a new trial, did not carry it through, so it got overruled, and then never filed a direct appeal. Ms. Draper will not be able to show you anywhere where they filed a direct appeal. And because he didn't carry out the motion for new trial or do the direct appeal, he can't then come say here, well, now I need a bill of review. We don't get to substitute one for the other. The reason why it's not an official mistake is because under the Texas Rules of Appellate Procedure, Rule 34.6, you are to file your notice of appeal timely and request the court reporter's record. That must be filed with the clerk and with the court. Mr. Hernandez never filed a notice of appeal. His remedy for there not being a court record for what she's claiming in his petition is through a direct appeal. Failing to use that remedy does not allow him to come here and say, well, because there was no record, I didn't do it. In fact, the argument is that you are negligent because you're admitting that you didn't appeal because you thought if there being no record, you can't appeal. He definitely could have. The rules of appellate procedure have the procedure on how to do it.
Okay.
If I can share really briefly, Judge, sorry, I just want to point out that we have it here. When there's a reporter's record lost or destroyed, how you can be entitled to a new trial when you file for it. And then there's a whole process that the trial court and the respondent must go through for the court to overturn the decision and bring it back. So I have all the case law here that says an official mistake is only when he relied on the court official and that made the judgment final. Not in this case where he had the right to appeal and should have appealed for the record and didn't exercise it. So we don't get to say the official mistake was not having the court reporter's record because that is an admission that he had the right to directly appeal. And Ms. Draper is saying her client's understanding was last year or earlier this year, he was told appeal, because this court also knows your remedy for this would have been a motion for new trial and a direct appeal. You don't use those, you don't get a bill of review.
Okay, so the Court of Appeals just had a case come out November 5th of this year, in Ray Austin. Are you all familiar with that case?
I am not, Your Honor. Was it the Dallas Court of Appeals?
Dallas Court of Appeals. No, excuse me, San Antonio Court of Appeals. It came out recently, and in this particular situation, it involved a bill of review. And the reason that husband or father was unsuccessful is because he was unable to show that he was prevented from making prevented from making a meritorious defense due to fraud or mistake that was not unmixed with any negligence of his own. And the court specifically found that he lacked due diligence in pursuing any sort of 306, Texas Rules Civil Procedure 306A post-judgment motion that would extend his appellate deadline. And the Court of Appeals found that that was a mistake due to his negligence and didn't give him the bill of review. So I guess, Attorney Draper, how does your client overcome that, considering that the motion for new trial was overruled by a matter of law, which shows a lack of diligence there, as well as I remember specifically instructing the attorney that represented husband formerly to file an appeal with the Court of Appeals, because I was not the judge that heard the original case, and the court's plenary power expired for me, and because the court's plenary power expired and I wasn't the judge who entered the judgment, I couldn't make any changes to it. And he had the opportunity to file an appeal at that time, but nothing was ever filed. So I guess I'm wanting to know, like, how does your client overcome that? Because according to the San Antonio Court of Appeals, that's what made his bill of review fatal.
So obviously I was not there, but from my understanding of the timeline, this order was signed in July, and the conversation related to him appealing did not occur until December. So by that point, it was well past his opportunity to appeal. He would have had to have filed a notice of appeal within 90 days of when the judgment was signed.
So Judge, if I respond, then, so what he's saying is, well, then I definitely had a lack of due diligence because I was only told by Judge Bailey this year, 2.5 years later, to appeal. So again, we're at the same spot where this man cannot state, I did do my due diligence. And as I'm pointing out, Judge, I have the Supreme Court that says the same thing you're saying in this new ruling. When you have available legal remedies and they're ignored, you don't get a bill of review. That's been the case since when, I mean, I'll share it, Judge. I'll share my screen. These are Supreme Court cases that I'm sure the San Antonio case is quoting.
Quoting the San Antonio case, they specifically said father received, and this was a default judgment. They said father received notice of the default judgment more than 20 days, but fewer than 90 days after the judgment was signed. Yet he did not invoke Texas Rules of Civil Procedure 306A to extend post-judgment deadlines. This lack of due diligence constituted negligence that was fatal to his petition for bill of review. Father's inaction could have been explained by either his failure to act or his attorney's failure to act. If the fault was that of the attorney, that circumstance was insufficient to support a bill of review. Similarly, a pro se litigant cannot rely on ignorance of his legal remedies to excuse his inaction. While the appellate court recognizes the harshness of the result, it also noted the necessity for there being finality to judgments.
That is what I'm arguing, Judge. That he's claiming he's got multiple problems. There's an official mistake. There's not. Not having a record is not an official mistake that prevented him from appealing. He prevented himself from appealing because he didn't appeal. He didn't carry anything through. Had he appealed, like I'm trying to point out, in the rules of appellate procedure, there is a way to appeal when there is no transcript, but you must file your appeal and you must use that legal remedy. He has not done that here. He cannot seek a bill of review 3 years later and claim that he's innocent in this. He has not. He has not performed any of the legal remedies he had. And according to what Ms. Draper is saying and what his client's saying, well, once I was told this year, I was already out of time. That is a lack of due diligence and on the record.
Yeah, Attorney Draper, I don't see how, and I have to meet all three prongs of it. I don't see how he can overcome, even if he were to overcome the meritorious defense portion, which the Court of Appeals, San Antonio Appeals pointed that out too. Even if it appears that an injustice has occurred, the requirements are so strict that I have to go by them. And I don't see how he can overcome the second and third prong of the bill of review about the, he was prevented from presenting his meritorious defense unmixed with his negligence.
I understand where you're coming from, Your Honor.
Okay. So the court is going to deny the bill of review.
Thank you, Your Honor.
Thank you all.
I'll get an order, I guess, Judge.
Yes, please. Thank you.
Thank you. Okay.
Court case where a man tried to cancel his divorce after 3 years, claiming he lost his property and business unfairly. But the judge denied his final appeal, saying it was simply too late for justice. If you want to see more shocking real-life judge verdicts and intense courtroom drama, make sure to subscribe to the channel right now.